Hello. Hi. Excellent. You can hear me. Welcome, everyone. I hope you're nice and toasty or getting that way with a jacket. Welcome. We appreciate you joining us today. This session is Lusting for Liability Protection. Sounds very glamorous. So my name is Katie C. I work with the Northern Brownfields Assistance Center, and I am a planner by trade. So I'm here to touch a little bit on the importance of planning, and I would like for my team here to introduce themselves.
Hey, I'm Jesse Richardson, and I'm with the Land Use and Sustainable Development Law Clinic at WVU. And I'm an attorney, so I'm here to scare the crap out of everybody.
And my name is Leah Mystic, which I think a third of the room already knows that. I'm a licensed remediation specialist in West Virginia, worked with, well, that says Montrose, and my tag says environmental standards. I'm not too confused with where I work. Environmental standards is a subsidiary of Montrose.
So for those of you in need, today's session will provide you with one AICP credit. Yay! So we just want to make note of that. So look for that. Hopefully it should already be showing up on the planning website or will soon. Okay. So what are some challenges to brownfield sites? Well, degradation of the environment, liability for cleanup, trying to understand who's responsible and who you would hold accountable. They can be eyesores. They're health hazards. They can decrease property values for those properties around them. Of course, that degraded a site can also result in economic ripple effect, right? So it not only affects that one site, but those around it and can impact the community. And certainly safety liabilities. There's certainly concern about a site that's open to folks being able to just access at any time, and if the building or the site is dangerous, and also can result in increased crime for, again, the neighborhood or the larger community as a whole. So that's kind of those are some of the obvious reasons about why a site known as a brownfield site could in fact be a challenge. And liability absolutely is one of the biggest ones that we all deal with a lot, and that's why we hope we can shed a little bit of that light on it for you today.
So what is liability? Well, from a lawyer's point of view, it is when are you legally responsible for injuries to people or to property or to the environment for that matter. And lawyers are always talking about potential liability. And it can really suck to be a lawyer because seriously, I had a friend, for example, call me one time and said, we got a mini trampoline and the neighbor's kids want to play on it. Can we do that? Absolutely not. What if we get them to sign a release? Nope, can't do it. Don't let anybody play on it, not even your kids. When it comes to CERCLA and leaking underground storage tanks and other types of contamination, some of the terminology. It's important to understand what a PRP is, potentially responsible party. And that's basically anybody who in any way had anything to do with that contamination. Owner, operator, transporter, anybody. And as we'll talk about later, that kind of informs our strategy when something happens. The first thing we do is try to figure out who are all the potentially responsible parties. Excuse me. And then the liability here is as bad as it can be if you're a defendant, because it is strict liability, which means it doesn't matter how careful you are. Doesn't matter what your intent was. If it's contaminated, you're liable. It's joint liability. That means every PRP who was involved in it is liable. And it's several liability, which means that if we have 5,000 PRPs and only one of them has deep pockets, the one with the deep pockets has to pay it all. And then, and that's what the EPA is going to do, is they're going to pick the easiest route to get their money. And then if that PRP who has to pay, if they want to get money from any of the other defendants, they have to sue them for contribution. So the EPA is basically like, we're going to get our money, then you all sort it out yourself. And then retroactive liability. And we're going to be focusing a little bit on underground storage tanks here. So I use an example from that. One of my first cases as a lawyer was the senior partner of the law firm called me up there because I was the underground storage tank guy. And he said, they had owned a car wash back in the 1970s. It had long been closed. And car washes there had underground storage tanks. They had gas tanks. They had closed them exactly how you were supposed to close them at that time. And then they had paved it over with a parking lot, and now there was a restaurant there. And that morning, the people at the restaurant smelled some gas odors. And the rain had pushed the gas from the underground storage tanks up to the surface. They had to dig up the parking lot, clean up all of the contamination, get rid of the tanks. And they called the senior partner of my law firm. And he's like, is that constitutional? And it's like, yes, sir, it is. Sorry. Yeah, it's retroactive. No matter when it happened, however long ago it was, if you did things the right way, you're liable. Yeah, so this kind of gets to the same thing. In a lot of cases, or a similar thing. Not only are those past owners who actually caused the contamination liable, but if you're an owner, let's say you're an innocent landowner, to use the legal terminology, then you are also liable for that because you're an owner. And the contamination is on that property, you may be liable as well. For example, looking at the railroad accident in East Palestine, Ohio, potentially the people where that was spilled on would be liable. But that's what we call a toxic tort. Some of you have seen the movie based in Parkersburg about PFAS. That's a toxic tort case as well. So you can have a lot of different defendants and a lot of different plaintiffs.
Let's talk about planning. So, because I'm the planner nerd here, want to set the tone for why it's important to establish your goals and create a plan when you're talking about your brownfield sites. So, you should, the benefits of planning when it comes to brownfields is because it allows you to establish the goals for you and the goals for your community. It allows you to talk with your community and include them in the conversation, not talk to them, because the only way to get true community buy-in is to include them and make them part of the process. Including the community also allows you to identify the target site or sites and the target area. So you may be looking to identify all of the brownfield sites or most of them that you can in your community. And having the community on board can help you do that, because Again, that includes them in the process. They may bring some to your attention that you just may not have been aware of. And then it helps you to understand the community vision. The reason that you want to have the community vision is that's kind of looking long-term. If you determine that your community may want to apply for an EPA assessment grant, the application requires a solid application that tells the story and provides the narrative of your community and the project. So you want to be able to describe the area, make it clear to the grant reviewers what's significant about the target sites or the target area. And that allows you to tell the story about just why you would need an EPA grant. And also the planning allows you to look at what's the magnitude of brownfields in your community? Is it just 1 or 2 sites? Is it numerous sites, enough that you may be looking to assess and remediate an entire block or, a few blocks within your downtown, but also magnitude has to do with liability as we're discussing here today. I'm a visual learner and I hope this is somewhat helpful for you. Just kind of gives a little bit of a timeline or actually it should be more of a roadmap. I'm sorry about that. But kind of starts with identifying your brownfield site or sites, and you're going along the road, and then you come to the process where, again, you want to plan, create your plan and prepare. And preparation can mean many things. It can mean finding your qualified consultants. And so it starts to include all these other elements, but having an awareness of the process and starting to assemble your team is part of your road trip. And so we talk about the importance of your team later on. So again, you find your qualified consultant. They can help you do a phase 1 or conduct that or the all appropriate inquiry. Please do not take ownership of a property without conducting a phase 1 or all appropriate inquiry, whether that's given to you or purchased. And then also further down your road would be risk assessment. We also get into that a little bit later, where you need to kind of weigh these risks. Is it worth it? Is it something you're prepared to move forward with? Do you have the team in place? And then based on the results of the phase 1 that you have, do you need to have a phase 2? And what is that phase 2 going to find? What are the results of that? And then ultimately that will lead to your remediation and redevelopment. Again, just wanted to reiterate, when you talk about the planning and looking long term, if you anticipate that you may want to apply for an EPA brownfield grant, you want to make sure that you do not take ownership of a property, again, before having conducted a phase 1 or all appropriate inquiry. That can make you ineligible to apply for an EPA cleanup grant if it becomes obvious that that is a need or a want for your site. And also phase 1s are, they must be completed within 180 days prior to taking ownership of the property. Yeah, sorry, my brain is still firing up from lunch. But so if you know that you're going to apply for a cleanup grant, you need to watch the timing of when you actually have the phase 1 prepared. And you can always update those, but we always like to provide that caveat. Leah, I think this is you. Do you want to move over here?
Okay.
Okay.
I'll bring it to over here.
Okay.
So my job is to just repeat phase 1 enough times that everyone like gets a little twitchy and has like that knee-jerk reaction when they hear the word phase 1 or property purchase. I know a lot of small communities too. You have folks who want to donate properties. Don't just take it. There's no such thing as a free property. It's just, why are they trying to give it to you for free? It sounds like a good deal. There's no such thing as a free property. But there's a lot of reasons that you will want a phase 1. I can't think of a reason to not get phase 1. There's no golden ticket to get rid of all of your liability concerns, but this is the silver ticket. I mean, if you have to go to a court and fight to say that you did not cause contamination on a property, evil Jesse is going to try to poke holes in that at every possible point he can for his client. They want you to be liable on the other side of that courtroom. What are they called? The little bars that you guys sit at. So in terms of just practical reasons that you want to phase one, your information is power. It's power when you purchase the property, because is that price they're asking a fair price? Are you going to be paying full price for something that you're going to have to remediate? You are going to want to know what it is you're buying. You're going to want to know its history. I know a lot of times that kind of smears the lens, those rose-colored glasses that we all want to put on when we see a new property and we have a vision. Please don't just think of the vision. Think of all the steps to get there. It's a multifaceted process. And knowing if it's contaminated doesn't have to ruin your vision. It can be handled, but you need to know what you're buying. And again, like Katie said, funding. Not getting a phase one really just like rips the rug right out from under you. You can't apply for an EPA grant if you haven't done your all appropriate inquiry because you're the responsible party. There are loopholes for everything. A lot of questions are probably going to be answered today with "it depends." We need more information. There's no black and white answer to any liability question without delving into the details. But there are some broad stroke generalizations that we can make. A phase one will only help you if you don't already own the property. If you already own the property, it gets tricky, but there's still a lot of really good reasons to get one. Jesse is going to beat you over the head with liabilities. I'm not going to do any more with that. But and then your risk tolerance. It's okay to walk away from a property if you're not comfortable with what's written in the phase one. You're going to get a 1,000-page report when you get your phase one done. Don't be intimidated. Your environmental consultant should be able to explain it in a half-an-hour conversation, at least to the point where you understand your findings. If they can't or they're not interested, it might not have been a great environmental consultant. But the bulk of the information is summarized in the first couple pages, essentially. Don't overlook those details in the report, but also don't harp on the fact that, oh my gosh, I got 1,000 pages of information. I don't know if I want to do this. It's all about risk tolerance. Get a team of people with you. You're going to see that on a couple slides. A team is invaluable. You're not expected to know everything about everything. Find somebody who knows about science. Find somebody who knows about law. Make them your best friends. Find a planner. Hang out with them. Do a presentation together. It's fantastic. You learn a lot about each other. But there's you're not the first one to have any specific story. You're not the first one to have found a leaking underground storage tank on your property. You're not the first person to not understand a phase one. People can help you through it. So if there's not a lot you can do wrong in getting phase one. Okay. Don't overlook the signs. Don't take the rose-colored glasses off. Be objective about the property. You don't own it yet. You know, talk to the owner. There are a lot of ways that, well, let's say, okay, say that you're buying a property and the old owner says, oh, well, I got phase one last year. I'll give it to you. Great. That's great background information. Do your own phase one. You were not the user in that phase one. It wasn't written for you. So that doesn't apply to your all appropriate inquiry. You need your own, and it's expired. After 180 days, the pieces start to fall off the phase one. But get one with your name on it as the user. Someone else's phase one is not nearly as good.
I just want to say that was my contribution to this presentation was Mothman picture. That's about it.
No.
I got another picture coming up.
Okay, so your phase one comes in. What is it? As a large paperweight. Well, not anymore. Now it's not even paper, flash drive. So your findings on a phase one can range from best case scenario to worst case scenario. Best case is your report comes back with a cover letter that says, please find your enclosed report. You have no recognized environmental conditions or RECs. There are some subsets to that. Does that mean you're not liable? Something's on the property? Absolutely not. Jesse will tell you that 100 more times. If something is still there, you could still be liable. Like I said, it's not a black and white situation, but it helps because the environmental professional has to go through certain standard procedures to make sure that certain historical documents are reviewed, certain interviews are conducted, certain forms are filled out. They cross all those T's and dot all those I's, so evil Jesse has a harder time getting you to foot the bill if something's found on that property, or if someone, your neighbor, goes to dig a swimming pool and they find some sort of petroleum product under there, and oh, it's from a tank on your property. Here comes evil Jesse. Oh, I did my phase one. Excellent, there's your silver ticket. You're in a much better position than someone who did not do that. So interviews with the fire department. I love talking to seniors and communities. They know so much about their towns and all the little buildings and all the old things they used to be. Sanborn fire insurance maps, fantastic. We're gonna have, go ahead, show the Sanborn. One. Some of you probably drove past this property yesterday or on your way in, and you would never know that there were all of these these are above ground storage tanks. Some of you know exactly where this is. It's just a blank property now. It is just a flat, it's just dirt. Looks great. If I didn't know any better, I would just buy it. Sanborn fire insurance. So that's one of the resources that your environmental professional is supposed to review. And then there's also the risk of if your phase one doesn't necessarily match reality. All these records aren't foolproof. There are gaps in data. They don't take an aerial photograph of certain neighborhoods every single year. There could be 10, 20 years between fire insurance maps. Things could have happened on that property where if you're digging your foundation, now you found something. If you're liable, it depends. I suggest a printed t-shirt says it depends. If you went with a very cheap consultant, you got your $2,000 phase one, it might not be compliant with current ASTM standard. It's easy to just put the new kid on writing a report. They don't know the standard. You get this packet back, you think it's fantastic. No, you gotta keep a cheap product that isn't going to cover you when evil Jesse comes to find you. So, are you liable if you still find things after phase one? Probably, but you're in a better position. You still have your silver ticket, and it's always going to be it depends. The partnership. Don't go it alone. There's always resources, there's opportunities for assistance. The Brownfield Assistance Center is phenomenal. They have resources and the things they don't know, they know people who know. Network here, go to the happy hours. By the way, there's a typo on the agenda. Happy hour tonight starts at 5, not 6. Network with people. Make your friends here. The partnership is key. Don't just throw a random environmental professional in and get your phase one. Have a nice day. See you later. Never talk to them again. You want somebody who's going to help you through the process, explain those environmental conditions, hook you up with a lawyer if that's something that you need. We're going to bring evil Jesse back, but that's okay. We'll wait for that.
Okay. Right, so we saw that.
Yep, Sanborn map. So my example of leaking underground storage tanks wasn't as cool as Jesse's, because it's not like a real world example, but he gave a perfect example of a property that everything was done by the books and there was still a leaking underground storage tank. So you ruined it. Thank you, Jesse. You ruined my example, but that's okay. No, I mean, and it happens often in leaking underground storage tanks. That's where lust comes from. That was the fish cult teach all in here. You're like, what the hell? So leaking underground storage tanks are one of the scariest things because they're unknown. You can't see what's under there. In a building, you can kind of guess if there might be asbestos. You can, with reasonable certainty, see if 55-gallon drums look rusty. You don't know if there's a underground storage tank, and it was really easy to just keep them there for a long time before regulations really started being enforced. It's a scary situation. and really, 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 really don't want to pay state up. If you do not have to.
All right, I think I'm next. All right.
It takes.
It's still waking up too. All right, how would I go about paying for this? So if you've done your phase one, you find something, you need to pursue that more. There are a few ways that you could look to pay for that. One of which could be cost recovery agreement with the West Virginia DEP. And that is where the owner would pay bills from the DEP. So if you're going to go through the voluntary remediation program, you do have to pay an application fee to the DEP. And so that is one way to help go through the process. But if you are looking to apply for an EPA cleanup grant, you could choose to go through the voluntary cleanup program through the state, through your specific state. But here we're talking about West Virginia, and the grant could cover the cost of the VRP program. So that is one helpful thing. Also, just point blank, is the EPA cleanup grant. That is a way to help pay for cleanup costs. And then also just another way we want to highlight would be the targeted brownfield assessment program through the EPA. So it is, rather than being a hard and fast deadline like the EPA grants are, the TBA program is a rolling application. And so you can work with that through the EPA, and that is for assessments, phase one and phase two assessments. And that is a really good way to kind of dip your toes into the water of a brownfield site, especially if you may not have the capacity or feel strong enough to be able to go through a grant process. That's a great way to get exposure to the EPA and let their consultant be the one who takes on the heavy lifting. Indemnities.
So it really hurt my feelings when Leah calls me evil Jesse all the time. So I'm not always evil. And I don't always want to scare people. So what can you do before you buy this property to protect yourself? Any type of transaction where you're dealing with a property that might be contaminated, and that's pretty broad. I mean, Leah talked about some of them, but a lot of these old farms had gas tanks, and they have multiple gas tanks, and we have no idea where they are, how many they are. Grocery stores had gas tanks, they were everywhere, car washes. But if you're gonna do it, you get your phase one, you might need a phase two. I think we talk about that later, right? But if you're gonna buy that property, one thing you definitely wanna do, or if you're gonna investigate possibly buying it, is you wanna have an indemnity and hold harmless agreement. Indemnity means that if you have to pay for something because of the other person's fault, they will reimburse you for that. Now, obviously, if I'm going to enter into an indemnity and hold harmless agreement with Leah, that doesn't make me feel very comfortable. Because how much money does Leah have?
$30.
Yeah. So your indemnity is only as good as who you are in that agreement with. And similarly, the hold harmless, that means that if they get sued for something that's their fault, they're not going to try to go after you. But again, the EPA or other injured parties, they can go after the deep pockets. And so the key is that you have to make sure that the person that you're contracting with has deep pockets. And you might want to get a letter of credit or a bond or something like that to back it up in appropriate situations. So here's how it usually goes. Let's say the transaction is today. Is today the 13th? Yeah. Okay. So Leah, I'm buying property from Leah today. And I'm foolishly going to do it with an indemnity and hold harmless. But I'm going to say that Leah indemnifies me and holds me harmless for any contamination that occurred prior to September 13th, 2023. And then I'm going to hold Leah harmless and indemnify her for any liability that happens September 13th of 2023 forward. So it's mutual indemnities and hold harmless. So that's how we divvy it up between the two of us. Another really important thing, see, I'm not so evilly, I'm giving out all this free legal advice.
I think I'm shady.
Yeah, she is, Emmett. And there's also this weird legal rule that says when you buy real estate, the contract merges into the deed. And so if we have a contract with all of these fancy indemnities and hold harmless, and then we do a deed and it's not in the deed, we're screwed because the contract disappears. So we also have to include in the contract this provision that this contract shall survive closing so that it keeps going even after the deed is issued. Insurance is not going to help you in this situation. So the best you can do is an indemnity and hold harmless. And you've got to be careful with that too. So in addition to, I think the phase 1, phase 2, possibly, that all appropriate inquiry. And I didn't know Katie and Leah were lawyers, but that all appropriate inquiry comes from CERCLA.
I had a decent professor in college.
You did? Who taught your law class in college?
I'll get you his name.
She's my former student, but yeah, that's from CERCLA and it's all over the place. If you have any hope of having a defense to any of these, you have to have done all appropriate inquiry. Anything I missed on that slide? No.
You have a look. The next one's fun. You ready?
Yeah, I'm ready.
Is your famous slide? Well, maybe.
There it is.
Yeah, the Phantom Midnight Dumper. That's my second contribution. So I was reading a legal treatise before I came here just to make sure I covered my bases. And they introduced defenses to CERCLA by saying that they are few and slim, which I guess is better than slim and none, right? But not much. It's very difficult. First is act of God, and that doesn't mean a big storm. I don't know of anybody who's ever proven this before. I think that you have to have a picture of God actually grabbing it and doing something. So that's not going to work. After war, if that happens, we're all screwed anyway. And nobody's done that either. So really, your only real hope is innocent landowner or actor or omissions of third party. And this is difficult as well. And I say Midnight Phantom Dumper because that's the classic story, especially in rural areas. You all know a place, I'm sure, where everybody dumps their stuff. When I was growing up, we called it Dump Hill. So that's why Leah does her interviews with old people like me. And yeah, I remember up on Dump Hill. And we used to go sled riding there until they built the housing development on it. But even if it's a Phantom Midnight Dumper, that you own this property, and people come by in the middle of the night and dump stuff on it, even in that situation, you have to show that you took all reasonable steps to prevent that from happening. If you knew or should have known that people were doing that, then maybe you have to put up a fence, or maybe you have to do something to prevent that. You also have to show that it was a third party. It was not somebody that you had a contract with. It was not your cousin or brother or something like this. This is an independent third party. Very difficult to prove, but it is possible. And you have to make all appropriate inquiry, and you have to take reasonable steps, and you can't just pretend like I didn't know. You know, like, gosh, I didn't know that. You can't willfully ignore the facts, and that can be really difficult to show that. Now, the innocent landowner, that was almost impossible until early 2000s, when there were some amendments made to CERCLA that makes it a little easier, but it's still very difficult. Again, not only do you have to make all appropriate inquiry, but you have to take all appropriate steps to minimize any liability that happened. And you can't contribute to the problem. And so it makes it so that you have to actively be preventing this and be involved in it. So innocent doesn't mean innocent bystander. It means innocent and actively preventing and minimizing the problem that you have out there. If you purchase the property and you did not know or should not have known that there was contamination. So now we circle back to all reasonable inquiry. What does that mean? Is a phase one enough? You do a phase one and you're good? Well, Leah already told you no. And the lawyer's favorite answer to any question, thanks for ruining that, Leah, is it depends. And it depends. Did your phase one show something that's a little fishy? And you might want to look a little more into it. And you say, well, I can't afford to do a phase two, so I'm just going to move on. That's probably not all appropriate inquiry. But it's probably more of an art than a science to try to figure out where is that line between you need to do a phase two and you don't need to do a phase two. Our governments have some protections under this as well. And all of this came in the 2000s because in the 1990s, there were some scary cases where banks were held liable. If the bank held a deed of trust on the property and it was contaminated, they were a PRP. So what that meant was all the banks said, I'm not loaning money on any of this property anymore because I might be liable. So the government had to come in and the Congress had to come in and provide some protection. If you inherit property, you might be able to take advantage of this defense. Again, did you inherit it and then just keep your eyes closed? Or did you make all appropriate inquiry and make sure that there's not a problem out there? So not only Leah said, people are going to give you property, that's a little fishy, but even if you inherit property, you can't just say, thank you, Grandma. You have to say, wait a minute. Grandma was a little suspicious. Well, she's storing something on the back porch. And in the early 2000s, they also amended the act to add a few other possible ways to get out of liability. If you're a bona fide prospective purchaser and you have all appropriate inquiry and you don't contribute to the problem, you might not have a problem. Residential property owners have some liability protections. And even contiguous property owners, we had to, because if your neighbor has a problem and it leaks onto your property, technically, under surplus, you're a PRP. Because you're the owner of the property, it's contaminated. However, the statute now says, if you make all reasonable and all appropriate inquiry, and all reasonable steps to minimize and prevent it from happening, all of that kind of thing, you can do that. But again, I think the key to this is we probably should have had shirts that said all appropriate inquiry. And on the back, it depends. Yeah, but yeah, always you have to make all appropriate inquiry and you have to take active steps. You can't just be passive and pretend like nothing's wrong and just say, don't worry, be happy. We're not going to have that t-shirt right now. You want to share first, or are we going to ask for horror stories from here?
We do have a captive lawyer. He can't leave for another half an hour.
That's right.
So
At what point does it cross over to liability? Can you have a property that falls over on the shoulder?
Mhm. Criminal liability would be either you intentionally or recklessly, knowingly did something, or it's going to turn criminal. In most cases, the EPA or the DEP or the agency is going to start out by giving you maybe a letter or something that says you've got a problem. And then maybe a notice of violation. And if the landowner keeps ignoring that, at some point, then they go to criminal. And so, in most cases, unless it's a really bad situation, they're going to start out trying to get the problem solved and they're going to start out with civil. But if the landowner just keeps flipping them the bird, then eventually they're like, okay, this is criminal. Any other insights?
How come you would still have liability by inheritance? You don't even, it's not even a voluntary thing to inherit the property. So, I mean, is there a way to not inherit a property that's given to you?
That's a great question and something that we talked about up here. Well, and they put this in here because of that issue. So one way is to be diligent and to make sure that that property is not contaminated. Another way is if you inherit something that you don't want because it's contaminated or whatever the situation is, you can file what's called a disclaimer. And there's a time limit to that. You can file it in the court and then you never own it. Yeah.
The liability, sometimes the owner or potential liability issues in long-term leaseholder.
It depends. But yes, the lessee can be liable as well. And I guess the one way that the lessee would be liable is the lessee actually was the one contaminating the property. But also if the lessee knew or should have known that there was contamination and they didn't do anything, or they took steps that made it worse, then there's liability as well. I should say, I think in a lease situation, if it's a potentially contaminated property, I would have indemnities and hold harmless between the landlord and the tenant. So that's another.
How does right to farm defense fit into some of this? Imagine there's gonna be the claim that DNDs and like best practices all galore and that's what farming is.
Yeah, right to farm has been invoked in a lot of situations, some of them rather humorous, but yeah, I can tell stories, but I won't. Right to farm is not a defense to any of this. It's strict liability, so unless you can claim one of these listed defenses, you're out of luck. The other strategy, though, is I might be evil Jesse, but I'm not the only evil one. Here's the strategy that we always use. If my client is a PRP, what I do is try to find every other PRP I can find. And with underground storage tanks, sometimes it's the oil company that owns the tank. So it's the oil company, any owners, any transporters. You do a title search, anybody in the chain of title, from the time the contamination happened forward is a PRP. And so we gather all of the possible PRPs, and then I send them all a nasty gram and say, either you pay for this or I'm gonna sue your ass. And a lot of times, the smart thing for the PRPs to do is get together and say, let's clean it up and split it between ourselves some way. Because if the EPA cleans it up, it's what we call a gold-plated cleanup. And it's gonna cost many multiples of that. And so sometimes that works. This is like no honor among thieves. There's no honor among PRPs either. They're gonna go after each other, and you can't, it's like being on Survivor, you can't trust anybody.
You wanna go to the top things to help you sleep at night?
I was gonna say, I have a question,
Okay.
I guess, for evil Jesse. On the flip side, what about when you are looking for a property and you find the perfect property that's already been through the voluntary program? Are there additional steps to kind of CYA on that? If you're gonna buy it, it's got its certificate of completion, but maybe there's still contamination underground.
I would still do an indemnity and hold harmless, and I think that's about all you can do. And then that I think goes smoothly into the next slide. Can you buy that property with an indemnity and hold harmless and sleep at night? Or are you gonna be up? I don't know. This is you, right, Leah? Or is
One of
that
you
you?
two, one of you two.
I can handle this. So again, we talked about the team, the law, planning, environmental, and you're fairly well covered on that then. Don't take ownership, regardless of how, although now I have a plan for enemies. Perhaps when I'm old and invalid, I'll buy a whole bunch of contaminated properties and then will them to people I don't like. Without telling, can you will things to people without telling them?
Yeah.
Okay,
Yes,
so
yes.
stay on my good side. Look into the VRP. We didn't really get into the weeds with the voluntary program, but it is a fantastic program. They, again, have seen, you can hear me without the microphone, right? I talk with my hands and it screws me up.
Well, but we get in trouble for those watching at home.
Okay. So the voluntary remediation program is a brilliant team of folks that wanted to see West Virginia succeed. Talk to them about entering the program. They'll tell you if it's not a good fit for you. And they'll also help hold your hand through it. Again, it depends. This should say it depends. We can't cover all scenarios in the session, but we want to reassure you that whatever situation you're in, someone's been in it before you. Someone will be in it after you. Someone has forgotten the exact same step that you forgot. Someone else took grandma's property and didn't think about it or found their storage tank. There are ways out of it. Don't panic. That was okay. That's stories.
Yeah, now I'm nice, Jesse. Do we have any success stories in the audience? No.
You guys are unsuccessful. Is that what this is?
I'll tell a story. I'll tell a story that I think is a success story. I had some clients one time, they were two guys, and they were not Bill Gates and Elon Musk. It was more mom and pop, little guys, and they wanted to buy a grocery store, an old grocery store. And so they hired me and they paid me. They did a phase one, and there was a gas tank on the property. And it was just a situation where, and I think the seller was like, well, that's your problem, not my problem. And they had already spent several $1,000s at this point. And they decided to pull the plug. And they're I still remember them because they're one of my favorite clients. They told me, because most people in that situation would have been yelling at me and not paying my bill and all that stuff. And then I would have had to sue them. But they said, we look at it like kind of getting a college education. We went through this process, we learned a lot. If we would have bought it, we might have lost even more money. So they decided that it was time for them to say no more. And I think that's what you have to do. You have to pick your tolerance level and at some point decide whether you're going to move forward or pull the plug.
So I think that a lot of you did hear the mayor speak this morning on Wheeling and its success stories in progress. Just this city in general has a lot of success stories that are in the making, and I think it's great to be able to see them. You see the before, during, and after. It's not just a picture of the old building with all the broken windows. Right now you're seeing the gritty bits, the lots that are still being developed and still being sampled. Wheeling itself is a success story that, if you weren't on one of the tours yesterday, drive yourself around. You'll see all the goings on. It's exciting to see. And yes, there were growing pains and learning curves and oopsies, and that's okay. It's all right. And Jesse, another one for you. What about our government friends? What about folks who have to do eminent domain? Are they liable?
I was surprised to find out that in West Virginia, they are. In Virginia, they're not. So you have to look at the laws in each state. Although there are some provisions that protect government, but they're going to have to go through the same steps as any other purchaser and make all appropriate inquiry. And that type of thing. Another success story that one of my clients had is Leah talked about the gift. One of my clients actually was contacted by a Fortune 500 company and said, we want to gift you this piece of real estate. And my client was smart enough to come to me and say, what do you think about this? And I said, why don't we do a phase one? Just for the heck of it. And we found out that the cost of remediating the contamination would have exceeded the value of the property. So that Fortune 500 company did what, no, that was Leah and Katie said, they picked somebody they didn't like and say, hey, let's give them this property, let's give them this liability. That's in contrast to most of my clients who, and these are all true stories. I get a phone call, hey, we found a gas tank on the golf course. I'm like, oh, okay, where is it? And they're like, well, we're digging it up right now. And so, yeah, please don't just dig it up or don't just do something. Talk to your team first. Any success stories for you, Katie?
I don't know, I've been in absorbing mode.
Any questions or where are we?
Yep, questions.
Yeah. John is one of my former students too, John and Katie. I run into him everywhere.
We were planning.
That's big. The environmental consultants in the room, do you have any stories of when the environmental consultant got sued and became liable?
Yeah, I do. And most of the time, I don't know what you all have in your contracts, but talking about evil justice, most of you all have contracts that say that you're not liable for anything. And that, you know, clauses that you're gonna do your best, but you're not liable for anything. Most of the time, as long as the expert is diligent and does what they say they're gonna do in a careful way, you're fine. I mean, anybody can sue anybody for anything. So the consultants need to document everything, be really careful, cross all the I's, dot the T's, follow those standards that you have. Where they get in trouble is where they don't, they're kind of lazy and they don't make those interviews, or they don't, or they maybe they see something and they're like, it's fine. And they don't pursue it anymore. So most of those lawsuits against the consultants are not successful. It's where the consultant starts to lie or can't document things that it gets sticky for you all.
We actually had a client who she inherited the gas station from her parents. Her parents bought it from a guy from a gas station before that contamination. What is her liability?
It depends.
Roll up and cry.
But if there's never been a phase one done, I would start with that. I think her responsibility is to make all appropriate inquiry. And decide whether, you know, do you need to do more than a phase one? You can't decide that until you've done phase one, I think.
She was gonna go ahead and just pull the underground storage tanks, get them closed and sell the property and move on.
Mm-hmm.
But with the presence of the former leak, it complicated matters because they put the tanks right in the old basin.
Yeah, that does complicate things. What, has she tried to sell it?
She has actually sold it
Uh,
to
you
the,
found a sucker, purchaser?
interesting enough, the guy who owned it first bought it back.
And that is like a dream, man. That's the best thing that could ever happen, man. And there's your happy ending right there. There's a success story. We gotta add that. Go to the former purchaser and see if they'll buy that.
Never heard of that
I
happening.
haven't either.
Is there any risk to a company who enters into like an option, like a lease option or purchase option before they execute, like during that period? Is there liability?
Well, that's why they added that prospective purchaser provision in the early 2000s. There is potential liability, but if you make all reasonable inquiry, you don't exacerbate the problem. And with all of these, if you find something, then you have to take reasonable steps to minimize it or prevent it. And so, yes, there is potential liability. Once you sign on the dotted line, you have a lot of responsibilities. But if you go through the steps, you can protect yourself.
I just want to say, we like to say, don't ever let the cost of a phase one deter you, because you can darn near always get that paid for. It could be through the state DEP, or it could be through a community's assessment grant. So at a minimum, you can get that phase one covered, and you may very well be able to get the phase 1, 2 covered as well. So, you know, we just always like to say, never, never let that phase 1 cost deter you, because if it's a smaller site, it's pretty nominal. Certainly goes up in size depending on that, but there's a very good chance that there's funding available. And I know we'll knock down doors here at the VAC to find someone who could take that on for you.
Yeah, I think that's what we want to leave you with. And are there any other lawyers in the room?
Yeah.
Oh, good, yeah. Yeah, don't tell any lawyer I said this, but it's not as bad as it seems. No, if we would have given this talk 20 years ago, you all would be very depressed. But over the last 20 years, what happened was 20 years ago, banks wouldn't lend money on these properties. Nobody would touch them. They were just sitting there, because if you breathe on it, you're potentially liable. So Congress, one of the few things I guess they figured out was they said, we have to do something, or these properties are never going to be put into productive use. So we've got more defenses now. They are difficult, but you can get a defense with these voluntary cleanup programs. Every state has one, I believe. We didn't have that 20 years ago, and they are wonderful. And you get participate in that. This is doable. You can do it. And like Katie said, you can get funding for your phase 1 and maybe your phase 2. So there's a lot more help out there than there used to be. You just have to be really careful.
And I'll just add, is my passing remark is that if you find yourself digging a hole, get yourself out of it sooner rather than later. Don't keep compounding mistakes. If you forgot your phase 1,
Stop.
okay, fine. Like, that hurts my feelings. But let's talk about it now. Don't keep going. Don't pull those tanks until you talk to somebody. Okay, you pulled the tanks. Oh, now you're still digging yourself a hole, but you can still climb out. But the sooner you climb out of that hole, and the sooner you kind of fess up and rip that Band-Aid off, the happier you're gonna be, the happier your wallet's gonna be, the less money you have to give to Evil Jesse. It's all around. It's gonna hurt when you do it, but it's gonna be much better in the long run.
Yeah, I always tell people, you can pay me now or you can pay me later. And if you pay me later, it's gonna be a lot more. So the earlier you do it, the better.
I don't know. I don't want to follow that advice.
I'm hoping Katie will say, and if you do have to pay Evil Jesse, we have grant money that'll pay him.
We will try. Thanks, guys.
Yeah, any other questions? Otherwise, you can find us around. I think we're all here at least for a little while.
Mhm.
Okay, thank you all.
Thanks, everybody.
Thank you.
I'm gonna go ahead. My panel's being rowdy out there. It's Russ. Good afternoon.
Hello.
This will be a lot funner if you're reciprocal. Good afternoon. Yeah, thank you, thank you. So welcome to PFAS Forever Chemicals, What You Need to Know. I'm Lydia Work. I'm a principal chemist, LRS at Montrose Environmental. I asked this last year, who in the room has heard of PFAS before today? Okay, anybody who in the room has not heard of PFAS before today?
There's at least two.
Oh, right, thank you, ladies. It was interesting, like last year, there was quite a number of people that had never heard of PFAS. So clearly a lot has happened in the world this past year that you're like, oh yeah, we've all heard about it. A couple housekeeping items, LRS certificates. LRS is in the room. See Ross Britton afterwards to get you a cert for credit for attending. There's a reception at 5 o'clock. I think there's a printed material that says 6, it's 5. Because you're attending PFAS and you're gonna need this, I've got drink tickets. So for attending this session, come see me. I'll get you an extra drink ticket. And then we're gonna hold questions and answers until the very end, okay? So I'm gonna have the speakers go ahead and get started. A lot of great material here. And we'll get going. Ruby is up first.
Thanks, Lydia. Let me know if I need to speak up any louder. Feel free to just call out. And for those who PFAS is still a new topic for you, I promise after today, you're going to start seeing it everywhere. And every time you open a newspaper or a website, it'll pop out at you. So this is just the beginning. Okay, so again, my name is Ruby Stanmeyer, and I'm one of the EPA representatives at this conference. However, I am not a Brownfields person, so I always like to start with that. But I've learned a lot since this is my second year now at the Brownfields West Virginia conference. I work at EPA Region 3 in our Philadelphia office, and I'm coming from the drinking water program. So I'm here to talk a little bit about PFAS in general, what EPA is doing, what they will hopefully be doing, and then focusing in on some of the more water-based aspects of PFAS. Okay, so to get started, some very basic background. What are PFAS, which the long term is per and polyfluoral alkyl substances. And it took me probably a year into my job to be able to say that without stuttering. So PFAS is basically an umbrella term. If anybody was at the QA session earlier today, I like that diagram. PFAS is kind of the umbrella, and then within that, there are thousands of different chemical structures and different types of PFAS. So the two on the left here are two of the most common PFAS that you typically hear about. So that's PFOA and PFOS, or PFAS. You'll hear it a couple different ways, but to distinguish PFOS from PFAS, I'll try to spell it out to make it a little bit easier. So those are two of the most common and kind of the original two PFAS chemicals. So again, like I said, there's many different types of PFAS and many different acronyms that you will hear, so it can get pretty confusing. And PFAS is nothing new, so we call them forever chemicals, and they started being used way back in around the 1940s in homes, businesses, industries. There's a lot of different purposes for it. And like so many other things, PFAS chemicals are extremely useful, and that's why they've been used for so very long. Just like we heard about earlier with asbestos, there's a lot of really great uses for PFAS, which is unfortunate. So you can find it today, since it's been being produced since the 40s, pretty much anywhere, everywhere you go in soil, water, and air. Most people have some level of PFAS in our bloodstreams at varying levels, and a lot of that depends on where you live and what's in your homes and kind of where you're geographically situated. And why are we concerned about PFAS? And that's because we know today that there are at least suspected or well-known toxicity effects that relate from PFAS. So that can be potential developmental, liver, immune, and thyroid effects. Some of these effects are pretty well understood, and some of these PFAS chemicals we have a lot of data information on, like the two on the screen, PFOA and PFAS, but a lot of them are new, we don't have as much information on. So another way we refer to PFAS, we can call them forever chemicals. They're also emerging contaminants. And that's because there's still a lot of information, a lot of things we don't know that we're still trying to play catch up, and we likely will be continuing to learn more for many years to come. And then lastly, the other major reason why PFAS is concerning, and it's also what makes it such a valuable chemical, and that's because it resists decomposition in the environment, but also in the human body. So once it's out there, it's not easy to get rid of, it's not going to decompose, it sticks around forever. So that brings us to a little bit about what EPA is doing at the federal level to try and address PFAS right now. So our current administrator, Michael Regan, came on board and was really set on addressing PFAS. So he established the EPA Council on PFAS back in April of 2021. And their first major task was to develop the PFAS Strategic Roadmap, which came out in October of 2021. And I know there's been at least one reiteration of it where they updated it and added some new items to that roadmap. But it's a really useful tool. It's really interesting just to read through it if you want to get some more information on what's going on. But it lays out a lot of different deadlines and actions from all the different program areas of EPA. So that's water, air, soil, Superfund, all of the different kind of program areas, and puts it into one place. So, and EPA is not alone in this either. There's a lot of other federal agencies that are also working on PFAS, everyone from DOD to NASA. So there's a lot of different players going on, and the roadmap tries to kind of bring it all together. So the diagram on the right I showed last year. So if you were here last year, you probably saw it then, but it's definitely one of my favorites. So I always try to include it whenever I do presentations, and it just shows the various different ways in which PFAS can enter the environment or that you can be exposed to PFAS. So that's everything from manufacturing sites up here, and that's, literally where the PFAS is actually being created, to biosolid applications, which is probably going to be a very hot topic coming up real soon if it's not already, and that's the application of wastewater treatment plant sludge onto agricultural fields, which can then contaminate livestock or food products, or also by runoff into the local streams and waterways. And then in the middle there, you can see there's a little airplane on fire, and that signifies airports can be a really big source of PFAS, and that's because there's something we call AFFF, which is aqueous film forming foam, firefighting foam, and a lot of firefighting foam has PFAS in it. So that's something that's a relatively new source, and now some states are starting to move away and require non-PFAS firefighting foam. So you'll find a lot of PFAS hotspots surrounding old military bases, old and current airports, anywhere where there's been firefighting activities. What else is good to know? Landfills can be a big source of PFAS, because a lot of times, what do we do with PFAS containing materials or even water filters? We throw them away. They go in the trash, they go to a landfill, and it becomes a problem further down the road in a different location. And then lastly, I come from the public drinking water kind of area. So we're dealing with PFAS in public drinking water sources and systems, but also private wells also can be a concern. And then lastly, in the bottom right there, consumer products. So we're not just concerned about PFAS in our environment, in our water, but also in our homes, everything from stain resistant carpets and furniture to food packaging. Fast food packaging can be a big source of it. So kind of the more you know, the more you'll see it everywhere, unfortunately. But so there's a lot of different kind of sources. So even though we'll be talking a lot about drinking water, that's not the only way that you can be exposed to it. Okay, so that was like a big lens. Now we're gonna zoom in a little bit on what's going on with drinking water. So I was curious, who here is served by a drinking water utility, public or private utility? Okay, most of us here. And then who here has a private well in your under property? Okay. So what's important to note is that EPA, as well as state governments, when we regulate drinking water, we are regulating public water systems. We don't have any authority to regulate individual household wells. So when I'm talking about these rules, it only applies to those of us who get our water from public drinking water utilities. So back in March, EPA proposed a new rulemaking, a new regulation under the Safe Drinking Water Act to regulate a couple different PFAS chemicals. And even though this just came out in March, it's been a many-year-long saga process to get these regulations out. So far, we just have a proposal. So everything I'm going to say is potentially subject to change, and we won't know for sure what the final will look like yet, but we hopefully will soon. So the proposal is establishing what we call maximum contaminant levels, more acronyms, yay, MCLs. And those are basically just legally enforceable limits that we can put on different chemicals. So we have MCLs for a lot of different contaminants out there. And we are trying to regulate 6 different PFAS. In the proposal, there are 2 individual MCLs for PFOA and PFAS, those 2 PFAS chemicals I talked about in the beginning. And then EPA is proposing to regulate 4 additional PFAS chemicals as a mixture and kind of a new way of regulating. And those 4 PFAS are PFH excess, PFNA, PFBS. Probably a lot of these acronyms don't really make sense or don't really apply to you. The last one, HFPO-DA, is more commonly referred to as Gen X. And that's a really big one, especially down in North Carolina and certain parts of West Virginia, you can find Gen X chemicals. And then lastly, along with MCLs, EPA is also proposing health-based maximum contaminant level goals, or MCLGs, which are basically another version of a health advisory. They do not take into account feasibility or testing or treatment. It's just, the ideal, what we wish we could get to, looking throughout the course of a lifetime. And what are those numbers? So for PFOA and PFAS, the proposal right now is 4 parts per trillion for each of those chemicals. And for context, because parts per trillion, parts per million, it's really hard to actually think about what that means. So parts per trillion is a very small amount and is roughly equivalent to about a drop of water or a drop of a contaminant in an Olympic-sized swimming pool, or a single second out of 32,000 years, which I thought was a very interesting way of looking at it. So 4 parts per trillion is not a lot. It's a very small amount. And I think it's the lowest MCL that EPA has ever tried to establish. The maximum contaminant level goals are currently 0 for PFOA and PFAS. So that just goes to show, obviously, the lower the better. If there could be no PFAS, that would be ideal. But we can't test down to that level. We wouldn't be able to prove that is happening. So we have to set an MCL that is feasible for both water systems and for our current technology in laboratories. And then the 4 additional compounds, I won't get into too much detail on the hazard index because it can get confusing and it's not really super relevant unless you are a drinking water utility. And this is not a final rule yet anyway, but it's a tool. It's called a hazard index. It's a tool that we can use to evaluate and regulate chemicals as a mixture. So if you do have more questions on kind of what a hazard index is, you can find me afterward. I'd be happy to go into more detail on that. So again, this is the proposal. And what would this require? So the proposed rule would require all of our public water systems and utilities that serve us to monitor for all of these 6 PFAS and then notify the public of the levels of those PFAS. So if there's a detection, then the utility has to notify their customers of that detection. And then if there's an exceedance, if it's above those MCLs, then the system has to work with the state and try to install treatment, or maybe they get a new source to reduce their levels to below that MCL. So like I've said a couple times, this is not a final action yet. So it doesn't require any actions from the states or the water systems, but people are very concerned both from a cost standpoint and what it's going to mean for public communication is another big concern. We are hoping that the final rule will be out by the end of this year. So we have a couple months to make that goal. We'll see if that happens. For context, the proposal was supposed to be out in December of 2022. And it was published in March of 2023, but that I will say that was not EPA's fault. OMB, the Office of Management and Budget, went through a 4-month review process, and that typically is only supposed to take a month or two. So that there's a lot of attention, and there's a lot of comments from other agencies like Department of Defense and NASA, interestingly enough. So the final rule, hopefully we'll know by the end of the year what that's going to look like. Compliance, typically water systems and states have about 3 years after the publishing of that final rule to actually comply with it. And then to kind of bring this back to brownfields and kind of what we're here for today, MCLs are often used as levels for screening for Superfund or as cleanup goals. So it can impact more than just drinking water. And then transitioning a little bit into how we're going to pay for some of this. We've talked about, and Adam during the keynote at lunch talked about how much money EPA has been granting and how it's grown a crazy amount. And that's because of bill or the bipartisan infrastructure law, which was passed, I don't even know, when was that, 2021? 2022? Doesn't matter. So Bill has a lot of money right now for emerging contaminants specifically. So we're really hoping that states and water systems and other entities can take advantage of all this historic funding. So there's a couple different ways that EPA is giving out money. And just for context, I just want to let you know, if you're here as a community group, you individually cannot apply for these funds. These are all state programs, but it's good to be aware of these as potential sources of funding. So $4 billion is going to be allocated through the Drinking Water State Revolving Fund, which is a state-based revolving fund program that gives out loans and grants. And it actually just recently moved to the Department of Environmental Protection in West Virginia. Which also oversees the Clean Water State Revolving Fund, which does, I'll talk a little bit more about the differences between those two funds. And so the Clean Water State Revolving Fund will be getting about $1 billion. And then lastly, we've been getting a lot of questions about this grant program, so I definitely wanted to mention it. It's a new grant program. It's the Small or Disadvantaged Communities Drinking Water Grant, and $5 billion will be distributed through that grant program. The first round of funding came last spring, summer, so states are starting to apply right now for that funding. It's a pretty large amount of funding, and it can only be given to drinking water communities who are small or disadvantaged. So I know West Virginia is working on their work plan and figuring out where all that money is going to go, because it's a lot more than we've ever had to give before. And then my SRF contact told me I should definitely mention that state revolving fund, SRF funds, can be used as a match as for an alternative funding source. So if you're doing a project and there's something that can work for either clean water or drinking water, then you can use those funds in addition to other federal funds or state funds. The Drinking Water State Revolving Fund, DWSRF, is pretty narrow with what you can do. It's very constricted to drinking water. So water treatment, lead service line replacements, consolidations, and it's a lot stricter with its borrowers. Only water systems can apply for this funding. But the Clean Water State Revolving Fund is a little bit more, has more options for people. As you can see, the list of borrowers is much greater. So nonprofit groups, businesses, community groups can apply for funds from the state. And there's some examples of different projects that can be done using these funds. So it can be a good option for communities, for towns who want to access either low interest costs or grant money to both install some new infrastructure and also help the water quality of your surroundings. So just looking ahead a little bit, and this kind of sets the stage for what my co-presenters will be talking about. There's a lot that is coming down the pipe right now with PFAS. So like we've already talked about, there's a final drinking water reg that's hopefully coming this year. There's a lot happening with surface water and ambient water quality criteria that is hopefully being finalized any day now. More data coming on PFAS in fish tissue and more laboratory methods to detect PFAS. There was a proposal last year to designate PFOA and PFAS as hazardous substances under Superfund, which is probably have the most impact on brownfields. And I know at least Matt will be getting into that topic. But there'll also be more research, more guidance for PFAS destruction and disposal, as well as potential Clean Air Act regulation, which I personally don't know much about, but that will be another kind of multi-pronged attack on PFAS in the environment. And then lastly, before I wrap up, I just wanted to talk about briefly the PFAS analytic tools, which is a very new website that EPA came out with in January 2023. And it can be a good starting point to just get a general look at potential sources of PFAS in your area, anything to be aware of. It combines, I think, about a dozen different databases of data and information into one mapping location. So some of it comes from Clean Water Act discharges. There's a log of spills in throughout the country, facilities that maybe historically have manufactured or produced PFAS, transfers of PFAS waste, and drinking water testing results, whether it's federal testing or state-based testing. And to find that, I included the website, but if you just Google PFAS analytic tools, it's the first link that pops up. And just play around with it. There's different the categories at the top of the search. You can, if you're interested in a specific category, or you can just play around, zoom into your town, see what's there, and it's just an interesting way to get some more information and data. So I'm going to stop there and hand it over to my colleague, Charlie Brown. That is his name.
And don't worry, it's a family name. My parents don't hate me. I come from a long line of blockheads. Sorry. Well, Ruby, thank you very much for that talk. I'm sure that information will stick with us forever. I'm not done yet. Okay. So as we had previously discussed, PFAS are everywhere. And this is due to a number of reasons. So their ubiquitous use in household products such as rain-resistant clothing, grease and water-resistant takeout containers, as well as for commercial aspects as well, such as chrome plating industries and Scotchgard. And also due to their chemical nature. So they are very persistent, they don't easily break down, but they're also highly mobile as well. So because of that mobility, that introduces a broad range of impacts from economic to environmental. So not only can PFAS contamination cause in a particular property decreased real estate value, but the mobile nature of it can cause it to spread to other adjacent properties. And with that spread, there comes increased problems with the testing and cleanup scopes, as well as the cost. And with that, the negative perception that comes along with those properties. But in addition to that, there's also environmental impacts as well. And those environmental impacts come with their own suite of, or their own concerns of cleanup and the costs associated with them. So here's an example. There was a study done by Florida DEP where they looked at historic dry cleaning sites that contain legacy PFOA and PFOS contamination. And what they looked at was these 15 sites, okay? And what they found was that at 5 sites, they found elevated concentrations of PFOA and PFOS. And they were able to positively correlate 4 of those 5 sites with the dry cleaner itself. So that's about a quarter, a little over a quarter of all these sites. And there's a concern associated with this that contamination of that site would cause, due to the mobile nature of PFAS, would cause the surface water contamination of surrounding areas. So the mobility of PFAS can be determined, or their fate and transport depends on the chemical structure. So in general, shorter chain PFAS tend to be more mobile in aqueous environments. So in this here, you may have PFAS that's introduced into the soil, but during a rain event or something similar may go through the soil into groundwater, and then there's an interchange, an interaction between the groundwater and the surface water. So even though the PFAS is, it may occur here, it may end up in the surface water through that mechanism. But also, longer chain PFAS tend to be more associated with proteins. So even though PFAS may, again, may be deposited here, it may be taken up by some insect, and through trophic level interactions, may find itself in here, by a fish that ends up eating that insect. Additionally, the head group of the PFAS can also impact how bioaccumulation occurs with it. So PFOA has a BAF of 198.6 liters per kilogram wet weight, where PFOS has 3,739 liters per kilogram. That is an order of magnitude greater. And so that is of concern, because if you have PFOS in an environment, say just aqueous environment, fish can take up and bioaccumulate this PFOS, in this example, fairly rapidly. And this is also a concern, because if you're trying to assess the ecological health of a waterway, fish can be used as a way of assessing the level of pollution in the environment. They're kind of like a sentinel species, or a sentinel animal, if you will. So, okay, you have this situation, and now you want to analyze the problem. One way to do it is through targeted analysis, and y'all may already be fairly familiar with these numbers right here, these methods right here. Methods 533, 533.1, and 537 they all test for PFAS in water. So drinking water, surface water, groundwater, and waste. And they test for 29 unique PFAS compounds, and typically run approximately about $150 per sample. And these are all, as I said, well-known types of methods, and many companies out there that do these analyses they will more than likely be accredited to do these. Method 1633 is one of the up-and-coming methods, and it tests for anything, or it tests for PFAS in any matrix, whether it's water, soil, or even fish tissue. It tests for 40 unique PFAS compounds, and the multi-lab validation for this methodology is still ongoing. However, the aqueous matrix has been finalized, so that is good to go. They're still working on soil and tissue. And I was on a talk once, or was listening in on a talk about method 1633, and one of the guys involved with the process, the validation process, mentioned that if you were to take all the data involved with the multi-lab validation and printed it out on paper, the stacks of paper would be enough to fill a small house. Like, it is a massive amount of data that they are trying to get a handle on. And typically this runs about $200 per sample. And I will say that by talking to a lot of my state counterparts, many folks have said that this is kind of the direction that at least the Mid-Atlantic is heading right now, is with 1633. So there are other types of analyses as well. So I'll talk about non-targeted analysis, and that's when there are no analytical standards required. An analytical standard, kind of in reference to what I just talked about, were those unique PFAS compounds. That is, those analytical standards are commercially available for purchase. And with non-targeted analysis, it identifies all known and unknown compounds, and those unknown compounds can be ID'd later. And what this analysis does in a very succinct nutshell is you can, based on the different structures of the chemical, it produces a peak or in a figure, in a graph. And so with a trained eye, by looking at these zigzags in a figure, you can kind of figure out what kind of PFAS are there. Another methodology is total oxidizable precursors. And yes, it is very expensive. And there's a reason for that. It's because essentially you have to run the sample twice. So in this sample, you're going to run your pre-oxidated, your sample, and you're going to get what you know. So you're going to have standards, and you can say, okay, I can positively identify this PFAS is in here. But we all know that there's more than just 40 PFAS out there. There's just, well, a lot more than that, tons. And so you have a whole bunch of unknown PFAS out there, some precursors. So what you do, so you have that first sample ran, you take a subsample, and then it undergoes this oxidation process under high heat. And what that does is it breaks down the polyfluorinated compounds, like the fluorotelomere alcohols, stuff like Gen X. It breaks it down. It takes it where that oxygen is, and it just chops it up right down the middle. And it turns it into the terminal compounds that we have standards for. So now, not only do you have what you know, but all these unknown precursors are then broken down into their terminal products, and you have a whole bunch of known compounds there. So you get a better idea of what the total concentration of PFAS is. Although it's not the original form, you can kind of suss that out. So back to that example. So, okay, a site investigation was warranted. Groundwater on the site was determined to cause surface water contamination. So at what concentration is the PFAS exceeding the screen level benchmark for surface water? And tying it back around to Brownfields. So this is where water quality standards comes in. And trust me, this will make sense in the very end. So water quality standards is how much of a chemical can be present in water before it'll harm aquatic life. It's a protective number. And it's designed to protect the aquatic community. And so not just the critters in the water, but the people who depend on it as well. So the people who would say, eat the fish for sustenance in those waterways. And the criteria derivation process starts with assessing the state of science. So what they do is they start out, the people in charge start out by collecting a large body of literature that looks at toxicity data of PFAS. That data then undergoes a QA review where they look at the quality of the science, the quality of the experimental design, and then they distill that down into what the most important or most valid scientific studies are. The effects data is then taken out. So what is the concentration of PFAS that causes mortalities? What is the concentration of PFAS that causes a negative or deleterious effect? Then that is further distilled down into a final single value, the criterion value. So here's an example here. And we have, and what they do is through these various scientific studies, a whole bunch of toxicity data is collected, and then it's ranked in order of sensitivity. So down here, we have the four most sensitive genera, of animals at the very bottom. And it's one goal of the EPA when making these criteria is to get a representative sample of animals. So you have animals such as invertebrates like insects, as well as mollusks. You have fish, you have amphibians. So this criteria is designed to be like a snapshot of the entire aquatic community. So those four lowest ones are then the geometric mean is taken, and that's your criterion. Once EPA determines that protection level, it's up to the states and tribes to adopt that criteria. And when they adopt that criteria, there are two sub aspects of it. That's the aquatic life, which is kind of what I was just talking about, the aquatic community, and the human health, which I talked about earlier with the people who eat those animals for sustenance. Oh, here we go. So here's the aquatic life criteria draft, and this should be published. This is currently the draft, so these numbers may change, but this should be published any day now. And again, this criteria must be adopted to be effective. But within the aquatic life criteria, we have two sub ones. We have the acute and the chronic. The acute criteria is designed to protect animals from death. These are high concentrations where in the experimental design, the animal is exposed for 1 hour, the number of mortality is in like a group of animals is recorded, and that's how you get that number. The chronic criteria is for sublethal concentrations, and this is designed to protect the population of animals. So, and this is not just like, it's easy to quantify something that outright kills an animal, but to assess that sublethal, those effects is very difficult. In these studies, they're not looking at, again, mortality, but they're looking at things that would impact how that population succeeds, whether it be early life stage development or reproductive success. And also that these, the chronic criteria is designed to protect the animals from bioaccumulation. And this is important because if an animal bioaccumulates a lot of PFAS and then someone, is going fishing and they want to eat that bass, that could be a problem. You don't want bioaccumulation to occur. So this is the human health criteria. This is where that comes in. And it's very difficult to establish this criteria because it's just such a multifaceted considerations you really have to think about. So not only do you have this rapidly advancing field of science that's very evolving and a lot of new data is coming out, so you got the animal side of things, but you also have the human side of things. What is the route of exposure? Is the person just eating that bass? Or are they somehow drinking some of that water as well? How often do they eat fish and how much of the fish do they eat? And what is the age of that person who eats the fish? So not only do you have that, but you have many different PFAS compounds as well that interact in different ways. And so while this is, although it says it's expected fall of 2024, I suspect it'll more than likely be winter of 2024, if not later. So, okay. If you have concentrations that exceed criteria, bringing it back around to brownfields here, the contaminant concentrations in surface water, if they are greater than the screening level, again, that's a water quality standard, it's then designated as a contaminant of concern. And if it's designated as a contaminant of concern, as you know, it requires action. That degree of action depends on the extent of contamination. So what is the concentration? How much PFAS is there in the water? What is the source? Is it that, is it the dry cleaner or is it somewhere else? Are there other sources of PFAS in the area? What's the media? Okay, is it the soil? Is it the groundwater? Is it some combination of that, or is it just the surface water? What is the pathway? How is that PFAS getting from the dry cleaner into the surface water? Is it, again, interacting with the groundwater, which is then interacting with the surface water, or is it surface water runoff? And what are the receptors of contamination, or to the contaminant? What sort of animals are you using to monitor the PFAS? Or is it people? But other screening levels may also exist as well. And unless you know otherwise, to my knowledge, I don't think there's any de minimis West Virginia DEP for
Not yet.
PFAS right now, and
Not yet.
EPA regional screening levels, there aren't any right now.
No, there are regional screening levels.
Oh, there are,
Yeah.
okay, okay.
Mhm.
But these also require their own level of screening and their own levels of cleanup and requirements as well. So it's something to keep in mind. And that is it for me. I hope you found this talk very fascinating. Thank you, Charlie. I guess that makes me Linus to his Charlie. So I'm Ross Britton, environmental toxicologist for West Virginia DEP. And I'm here to talk about PFAS specifically to West Virginia. And interestingly, the whole PFAS issue hit the fan here in West Virginia, in just outside of Parkersburg at the Washington Works Chemours plant. And it all started with a very stubborn dairy farmer named Wilbur Tennant, who has unfortunately since passed away, who refused to believe that he had over 100 dead cows because of anything that he was doing. And he hired a good lawyer. And the two of them together are the reason we are now talking about PFAS. They brought the whole issue to light. And if you want to know about their story, highly recommend if you haven't seen these yet. I personally love The Devil We Know. It's a documentary where you get to know these individuals who are involved with this, not just Wilbur and Robert Ballot. And then there's also the Hollywood version of things, Dark Water, starring the Incredible Hulk, Mr. Mark Ruffalo, as the lawyer Robert Ballot. I'm sure Robert was flattered to have him represented by the Incredible Hulk. Real quickly, PFAS is in a whole lot of stuff. We thought that originally it was Teflon and drinking water, or how people were going to be exposed to this. That was the primary issues of exposure. We have since come to realize it's actually, as Ruby mentioned, it's our clothing, it's our food packaging, it's our makeup, things like that. That is where we're getting the PFAS primarily, unless you happen to live in a place that has contaminated drinking water. Then that will most likely be your primary source. From a toxicity standpoint, generally speaking, the more we learn, the more concerned we have become over time. Adding on to what Ruby mentioned about toxicity earlier is renal or kidney issues as well that we're noticing with this. PFOA is the only one so far likely to be, and this wasn't mentioned in terms of numbers. There are at least 14,000 different PFAS compounds out there. That's the minimum size of the PFAS universe. Okay, the number keeps growing. And we have only one that we has currently been designated as likely to be carcinogenic. That's PFOA for kidney and testicular cancer. There was a very recent study just a couple weeks ago that linked testicular cancer to PFOA for military personnel in the Air Force, specifically exposed to AFFF. So that likely to be carcinogenic for PFOA is likely to be increased to a known carcinogen, human carcinogen soon. We currently only have non-cancer toxicity values for 23 PFAS compounds, and most of those are actually surrogates. We only have good toxicity values for 6 compounds. That's it. Those happen to be the 6 for which we have proposed MCLs. The rest of them are just assuming that they're similar to the ones we've got toxicity values for. And of course, only one currently cancer toxicity, and that's for PFOA. PFOA and PFOS are the 2 most studied. They're the ones that first came to light. They were the most used originally, and they're the ones that first came to light. There's very little cancer research on there. On them. The whole cancer aspect of PFAS is just beginning. And that's compared to the non-cancer stuff that is really still in its infancy as well. As an example, the non-cancer toxicity effects for PFOA and PFOS were estimated in 2021 to be more than 1,000 times worse, more toxic than we had thought before. And that one had been like at least 100 times more toxic than we had thought just a few years before that. We keep going. The big thing that's driving it right now is immune responses. Our immunizations, it impacts our ability for our immune system to respond to the vaccines. And to give you an idea of the potential scale, there's presumptively up to 57,000 PFAS impacted locations across the country, from industry, from military sites, any Air Force base or airport, major airport, industrial facilities, wastewater treatment plants, landfills.
within the state of West Virginia, of course, the legislature has taken a notice of the PFAS issue in West Virginia. Back in 2020, they requested the DEP and the Department of Health and Human Resources to start looking into our public water supplies and start sampling them. We'll get to more on that in a little bit. In 2021, House Bill 2722 amended the Fire Prevention and Control Act to specifically limit the use of AFFF that has PFAS in it, and added on a rule from that particular bill that actually designated specifically how the fire departments are allowed to use AFFF as part of their training purposes. And lastly, for the fire department, also how to dispose of their old AFFF that has PFAS in it. They're trying to collect that right now and get rid of it appropriately. And here's the big one that the legislature just passed. It is the PFAS Protection Act, just effective this past summer. And it's mainly a to-do list for the DEP. That's mainly what it is. Starts off with a DEP action plan that by this next July, we have to develop these action plans for any site, meaning any public water supply where the raw water, that's the water coming directly out of the ground or out of the river, or anywhere the raw water has PFAS concentrations that are greater than a practical quantitation limit and greater than the health advisory, not the proposed MCL, but the health advisory, which is much lower than the MCL. The PQL, for those of you who are not analytical chemists, I'm going to give you a very brief introduction to how chemistry works. When we can never know an absolute zero with analytical chemistry, there's only what we can detect and what we cannot detect. And even what we detect is somewhat fuzzy in certain concentrations. The PQL is where we have good, strong confidence, usually 99% confidence that it is the chemical is not only there, but the value that came out as a concentration is accurate, and we can have some faith, so to speak, in that particular value. By comparison, the MDL, the method detection limit, says that we can tell the chemical is there, but we're not confident in that value. Don't put much faith in that particular values, right? So there's the PQL, which is the highest level, the MDL below that, and then below the MDLs means it's not detect. Doesn't mean it's not there, just means we can't detect it. So if it's above the PQL and the health advisory level, if in the raw water, make the action plan. And then you also have to sample, we have to sample the finished water. That's what people are actually drinking after it's been treated, for the sites where that raw water had exceedances of PFAS above the MDL and the hazard, the health advisory level, but still below the PQL. So these are what we call J flag values between the MDL and the PQL. We have this confidence. Then we have to have an action plan for those finished water sites by the end of 2026 that had exceedances of the health advisory level that in the finished water. And then we have to recommend any changes to our applicable statutes and rules to address PFAS sources, that's the industry, and also annually report to the Joint Legislative Oversight Commission on State Water Resources. And the one thing that it does that doesn't really directly involve DEP is the facilities that are using and manufacturing PFAS, if they're knowingly discharging any PFAS to a surface water body or to a publicly owned treatment work, a sewage treatment plant. If they've been doing that since the beginning of 2017, they must report those discharges to the DEP by the end of this year. And if any of you out there are in the consulting field, the letters started going out just in the last couple of weeks. If you're working with one of those industries, they may have already gotten on the phone with you saying, what is this thing about NIPT's permits and PFAS, right? That's what this is about, legislatively mandated. Once the EPA finalizes the Clean Water criteria, Clean Water Act criteria, DEP must also propose criteria that is no more stringent than EPA's criteria in the next legislative rulemaking section, because that's how we get our state water quality standards. The legislature has to go through that process. We also have an interagency PFAS work group. It's a very informal group composed of members from the DEP, the DHHR, US Geological Survey and the Division of Natural Resources as well for West Virginia. Meet quarterly, and it's a collaborative group to try to get ahead of the issue, right? Our goal is to determine the best path forward for PFAS and how we're going to implement the new federal regulations that are coming our way from people like Charlie Brown. All right, so the drinking water study. And this is already published information from back in 2022. We sampled all 279 public water supplies. Actually, USGS did this on behalf of DEP. All 279 public water supplies throughout the state in the raw water, not the drinking water, just pre-treatment. Tested it for 28 different PFAS compounds. You can look at this data just as well as I can. It's publicly available, as I mentioned. And what you see here are some interesting things, something that is not too particularly surprising, but hey, the number of different PFAS compounds you have in the water, not a big surprise, the concentration of total PFAS goes up. So the more different types of PFAS you have, the greater your total PFAS, which makes sense. What's interesting on this one over here is you see this is the carbon number. How many carbons are in that chain for the PFAS? And looking at the frequency of detections. And what you see is C8, carbon 8, when you have 8 carbon. That's why the people in Parkersburg, they originally know PFAS as C8, and they still refer to it as C8, because what they had was these two big boys here, the PFOA and PFOS. The carboxylic acid at C8 is PFOA, the sulfonic acid or sulfonate at C8 is PFOS. Those are the two big ones. They're what's driving everything. So you see, those are what's most frequently detected in our water supplies as well. So focusing on PFOA and PFOS. As the old health advisory level was 70 parts per trillion, our new interim health advisory levels are down to 0.004 parts per trillion for PFOA, which we cannot detect. That's why the MCL is 4 parts per trillion. That's our reliable PQL. That's why that MCL is right there, because below that, we can't reliably detect the concentrations. And any site you see here in West Virginia that is not colored white exceeds either the HAL or the proposed MCLs for PFOA and PFOS. You notice most of those along the Ohio River and out in the Eastern Panhandle. That's our kind of our primary problem areas. So PFOA was detected in 29 of our public water supply sites, ranging from anywhere from 4.4 to 1,500 nanograms per liter, which is parts per trillion, by the way. So exceeding the proposed MCL by 3 orders of magnitude. For PFOS, we had 16 detections among our public water supplies, ranging anywhere from 4.5 to 97.9. Of course, all those also exceeded the proposed MCLs. I will say 8 of those 16 detections were uniquely just PFOS. They had no PFOA in them. The short chain PFAS, the Gen X, PFBS, PFNA, and PFHXS, we had 10 sites that had exceedances of the proposed MCLs. And this is the first time EPA has ever proposed an MCL based on a hazard index. In the risk assessment business, we use hazard indices all the time to assess cumulative risk impacts. This is the first time they've ever done it for an MCL. Brand new thing, and there are going to be some programmatic implications and complications coming from this as we implement this, but we'll get through it eventually. All of those 10 sites that had exceedances for the short chain, only 2 of them were unique, didn't have PFOA or PFOS as well. So 39 sites had some sort of an exceedance of the proposed MCLs. Looking at the raw water just for PFOA and PFOS here, again, and this is from our standpoint at DEP and also in DHR, this is where we start getting concerned. We had 13% of our sites have confirmed exceedances, right? That's not good, it's not horrible, but it's also not good. This is what concerns us more. Only 5% can we confirm really have no exceedances in them, because it all gets down to that practical quantitation limit issue, okay? 136 sites detected, nearly 49% of our public water supplies have PFOA or PFOS in it. This is one sample in time. To think that that one sample in time is gonna represent all PFAS concentrations or PFO and PFOS concentrations in that public water side supply from now till eternity is ridiculous. These things vary, so that means we need to go back and resample those again and see what they're like. Also, and this is the big one, right here, you notice these nice big bars on the chart. Non-detections where the PQL was greater than the MCL. Right, the PQL was somewhere from 5 on up to like 15. And that means we can't say anything. We don't really know if we're exceeding or not. That's 82% of our sites. So that we have some potential issue in there because of that. Okay, all right, so we'll try to get through this quickly. Actually, I'm gonna skip the total PFAS then. General conclusions and issues. 57% of our public water supplies had detections of at least one PFAS. As I mentioned already, Ohio River and Eastern Panhandle, the big things. We need to know the finished water, which we're working on, and again, only one sample in time. Looking at the finished water for PFOA and PFOS, the 39 sites that had exceedances, we went back and sampled their finished water. 41% of those, 16 of them had exceedances of either PFOA or PFOS in the finished water, right? This is what people are actually drinking now. So it's telling me that roughly half of the raw water exceedances are still having problems. 16 of those, like I said, had exceedances of PFOA and PFOS. One more also had an exceedance of the health advisory for Gen X, okay, in the finished water. But there was no exceedance of the health advisory for Gen X in the raw water when that was sampled about a year before. Remember I was talking about temporal variability? That's likely a temporal variability issue. Or there's a source of Gen X somewhere within their system between the source and what they are treating it for. Within DEP and the OER, we are treating our PFAS sites currently through our Department of Defense sites primarily. Jake McDougall is here. He heads up that particular program. These are federal sites. The big ones are the Shepherd Air National Guard Base in Martinsburg. They have a known PFHXS issue there, and karst topography, so it's traveling all over the place. And we have a known issue in the Allegheny Ballistics Lab as well. The others are currently being assessed for PFAS issues. From a brownfield standpoint, we have our certificates of completion, of course, under VRP, that absolve our brownfield applicants of liability issues at the state level, but only for the contaminants that we have addressed at that particular site. PFAS was not historically addressed at those sites, so our certificate of completion recipients in the past are still on the hook, potentially, for any PFAS that may be associated with the site. You can get federal liability relief. I'll let Matt take that stuff and switch to just what we're talking about with VRP. You can address PFAS within a VRP. We have not had a site address that yet, but it is possible. You can move the brownfield sites through VRP and get your state liability relief certificate of completion that way. Federal liability relief comes for Superfund stuff. The new ASTM standard is probably the best way to do that. Older test methods that we want you to do if you're going to bring a site through VRP. We want you to use the draft method 1633 because it has been approved for water now, and it's still, as Charlie mentioned, so it's still in draft form for solid samples like soils and sediment and tissue. But it's the only method that can even do soils, sediment, and tissue. So you're going to have to use that for those media anyway. So use 1633, follow that up with either TOF or TOP so that we can get a picture of what the total potential PFAS is. Because one of the things that wasn't mentioned is with PFAS, they're forever chemicals, but they're not always in the same form forever. A lot of our precursors, the fluorotelomers and things like that, they will actually modify into the longer chain, break down into longer chain, more complex molecules, the C8. PFOS and PFOA. That stuff is more forever. So we want to get an idea what the total picture is. There's no West Virginia certified labs for PFAS yet. I talked with Justin Carpenter, who heads that program, and they are anxiously anticipating that. They will update or get the labs certified as soon as possible. As soon as we get that Circle of Hazardous Substance designation from EPA. And we can make decisions on a site-specific basis in terms of which PFAS compounds to target for your particular site. You know, talk to DEP about that. Once you get your values, you can use the EPA regional screening levels that are currently available. And once we get that Circle of Hazardous designation or an MCL designation, either one, we are prepared at DEP to immediately develop our de minimis standards for those PFAS compounds and update our guidance manual and SOPs to reflect how you have to sample them, because sampling for this stuff is not easy either. It's very different. A lot of our old sampling materials have PFAS in it that could contaminate your sample. So it's a mess. And I'm done.
Hard to stop once it's going.
Starting my stopwatch here. For the end. Hey everyone, my name is Matt Wood. I am an environmental attorney with Babs Callan in Pittsburgh, and my practice generally revolves around remediation issues, both for legacy contamination at various sites under CERCLA and the state analogs, and also with active operations that may have remediation issues that they're dealing with. See if this thing works. There we go. All right. Little caveat there. This is not legal advice, but be sure to talk to your lawyer or your environmental professional if you have site-specific issues. So
To the lawyer.
Yeah. So the Brownfields process, basically a broad overview is that, when you're looking at a site, you're going to investigate, you're going to investigate a little more, investigate a whole lot more. And then based on all that, you're going to decide how to address the site based on how you want to reuse it. So I'll go into a little bit more detail on the initial step, which is the phase 1 environmental site assessment, in a few slides. As Ross mentioned, in West Virginia, they have the voluntary remediation program as an option to work through this process. And that is basically a kind of an incremental step-by-step process that you work with DEP to, you apply for the program, you kind of develop your plan. You can perform a site assessment and a risk assessment to use site-specific standards to clean up to certain levels other than the regulatory levels that might be prescribed. Submit a report, remediate, submit a report, and then get that certificate of completion that Ross talked about to get some of the liability benefits, liability protection benefits from the state. So VRP eligibility, basically this comes down to if somebody's already forcing you to clean up the site, you're probably not eligible for the VRP program because you're doing it some other way. Also, if you were the one that through gross negligence or willful misconduct contaminated the site, you're also not eligible, which makes sense. Some of the potential benefits, as I mentioned, the liability protections. After you apply, if that's in good faith, there's no enforcement action for the subject contamination. And you also receive liability relief, state liability for the release that caused the contamination. Public and private claims are barred for that subject contamination. And then, as Ross mentioned, from the federal perspective, if you go through the all appropriate inquiries process, you may get federal relief from liability for the subject contamination. As I mentioned, one of the other benefits is that this is a structured process. You're working with DEP under the VRP to go step by step, and you get the benefit of talking to the experts at DEP through that. Some of the opportunities for brownfields, I'm sure you're all aware, there's a perceived diminution, reduction in value for a lot of these properties if they're contaminated or perceived to be contaminated. So if you're looking for a property to redevelop, you may be able to get that property for a lower price. One of the drawbacks is that it may be more difficult to finance if you're looking for financing. Okay, so the initial step, phase one environmental site assessment, many of you are probably familiar with this, but it's taking that first look at a property to see whether it might be impacted by contamination. And sometimes this is described as like a desktop review, because you're looking at like, documents, you're looking at the history of the site, you're looking at aerial photographs, you're going to do a site visit. But at this point, you're not sampling, you're just trying to figure out if there's an indication that the site might be contaminated. So the most recent version of the phase one standard, it's called E1527, that was published in 2021. And it was the first version to address PFAS or PFAS. I say it both ways, always switching off. It's the first version to address those at all. And I'll get to how they address that here shortly. But I'll skip the bullet points here. You guys can review that if you want to. But the last bullet point, the EPA published the final rule to accept the newest standard for use for the all appropriate inquiries standard under the second bullet there to obtain federal liability protection. They published that in December 2022. So some of the updates in the phase one ESA, they updated definitions, they updated some timing requirements. But the most significant one, I think, from my perspective, is that they added that discussion about PFAS. And the way they did that is they defined PFAS as potential business environmental risks, and more broadly, substances that are not defined as circular hazardous substances are potential business environmental risks. So the threshold here for whether or not you might consider adding PFAS to the phase one environmental site assessment is whether they're defined as hazardous substances under CERCLA. That's when you have to do it. Right now, you don't have to do it, but because it might affect your business, you might consider doing it, if that makes sense. Let's see. So as we mentioned earlier, EPA proposed the rule to designate PFOA and PFOS as CERCLA hazardous substances. That was in September 2022, and then followed that up in April 2023 with an advance notice of proposed rulemaking for they want public input on whether or not they should designate additional PFAS compounds as hazardous substances under CERCLA. So at the moment, February 2024 is the target date for this PFOA and PFOS designation final rule. That was pushed back, I think, from August originally. So it's coming up, but it also leaves the phase one environmental site assessment and whether to include PFAS in that kind of in limbo. So a little detour here. Some of the downstream effects of designating PFOA and PFOS as hazardous substances under CERCLA is that it empowers and gives EPA additional authority to enforce investigations and cleanups, as well as recovering costs for those investigations and cleanups. One of the big questions right now, and EPA holds some listening sessions to address, not really to address questions, but to talk about the fact that they're going to be releasing at some point an enforcement and settlement policy to address kind of these entities like POTWs, municipal landfills, people that use biosolids that are the receivers of PFAS, but we're not like the generators of it. There's these downstream receivers that are really like, look, we're doing our job, we're providing a service to the city or whatever, and we shouldn't be forced to investigate and clean up because it's not really we're not the ones that did it. So EPA said that it's going to be pursuing the manufacturers and the large dischargers of PFAS, that those will be the targets, and that they'll have this discretion and settlement policy at some point to address some of these other entities that may be affected by PFAS but did not generate it. But we don't know when that's going to be published. So once that is published, it's probably going to inform a lot of the decision making around brownfields programs and investigation and cleanup. So the question, overall question, I think, is on this initial step with the phase 1 ESA is, do I want to include PFAS in my investigation? Do I want to learn if it's, you know, impacting this property? And I think obviously every site's different. You want to talk to your attorney and your environmental professional, but I think generally, you know, if you're approaching this property and you want to try to obtain some of the, you know, liability protections, especially under like the BRP program, you probably want to understand what's going on at the property. And then, let's see. And Ross kind of touched on this. I mean, so let's say you already have a COC. It addresses certain chemicals, you know, like say it's metals or, you know, chlorinated solvents. You have protection against those, but if you didn't approach the property at the beginning and identify PFAS as an issue that you address, then you might be on the hook for investigating, cleaning those up if they're discovered on the property. And then also DEP has the option to reopen voluntary remediation agreements. That's one of the initial steps in the BRP program. If you know, new information comes to light, if there's new contamination, if they discover that the contamination is, you know, way more concentrated than initially thought, they can go back and reopen that. So some other notable items, you know, as Ross mentioned, DEP just started sending out these reporting requirement letters to permit holders that either discharge to surface water or to POTWs. EPA and other state agencies, they're sending out information requests. If you have a site that's near a PFAS groundwater contamination plume, they might send you an information request to say, hey, tell us about your operations. We want to understand whether you might be a source for these. I work on a few sites in New Jersey, and the sewer commissions there, they sent out surveys to their permit holders to try to, you know, ask a bunch of different questions about how operations worked, whether or not they had AFFF systems on site, whether or not there's ever been a fire. I mean, they're asking every little question to try and track down whether these industrial permittees might be sources of PFAS downstream. And then Ross, he mentioned the PFAS Protection Act, which we touched on. One other thing I just noticed, I mean, I think a lot of us think about this from the perspective of the environmental realm, but, you know, I had a recent experience where a property owner, a client came to me with a lease and said, hey, look at this, the environmental provisions of this lease. Our client wants to potentially lease this property from the property owner and put this business on it. And in the lease, the property owner included language that basically said the lessee cannot use any materials in their operations that have PFAS in them. Wow. I mean, it was so overly broad. I mean, even for a small business, that would be an impossible thing to, you know, to nail down. And you know, they went back and told them the appropriate response to that lease language. But just as an example that, you know, people are thinking about this and I think a broader perspective. And I think that, you know, the fact that last year when we did this conference and did, you know, spoke, a lot less people were aware of PFAS. You know, when Lydia asked people to raise their hands, and it's kind of heartening to see that people are, you know, kind of, yeah, it's on your radar, and you might understand some of these issues that are affecting everyone. So I think that's all I have. So if you have any questions, I know that was quick. We're coming up on our time here, but feel free to email me if you have any questions about my presentation. And thanks so much.
Yeah. I had that mic. All right, thank you so much for coming. Are there any burning questions out there? Matt.
In BRP in the near future, since up there is dry cleaners, you're gonna have to add that to the contaminants potential concern and be thankful and
Most likely, yes. And a lot of it's going to depend on timing, things like that. But, you know, anything that had, any site that was a dry cleaner involved, any site that had chrome plating involved in it, that had AFFF on it, stored on it, or used on it, That means that'll be the check that we need to investigate. Well, if you want to include PFAS under your voluntary agreement.